Good day, Crime Talk aficionados. We have a great show for you today. First, the defense says the government's gun evidence is junk science in the Delphi murder trial. The prosecutors in the Daniel Penny trial refer to him as the white guy. Lori Vallow's new attorneys withdraw the motion for competency evaluation for Lori Vallow. And the prosecutor in the Barry Morphew case is now officially disbarred. A Texas man gets sentenced for protecting his stepdaughter's honor. A case in Florida where a quick hookup went terribly wrong. This day in legal history is related to Election Day and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, Crime Talk aficionados. Thanks for joining us. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out anytime as well on any of your favorite podcasting apps. Now, before we get to the topics of the day, first, go to crimetalksearch.com. Sign up for that background subscription service, which you can cancel at any time. But while you have that background subscription service, you can do as many background searches as you desire, all right? And you're going to get a report literally as you wait, and it's going to be emailed to you, and it's going to have information on that individual's background, where they live, who they are associated with, where they reside. Do they have a criminal history? Do they have judgments, liens? A lot of information about their social media. Why do they have 10 email addresses? Could it be because they're signing up for those dating sites and they don't want to use their own information? Yes, go to crimetalksearch.com and check it out. You're going to be happy that you did. All right, let's go ahead and open the record for, that's right, November 5th, Election Day here in the United States of America. And let's get to it. First, the trial of Richard Allen continues here on Election Day. They're in Delphi, Indiana. And for those who aren't familiar with it, Richard Allen is accused of killing two teens who went missing back in February of 2017, and they were ultimately found dead on February 14th of 2017. Now, he was arrested in 2022 and faces multiple counts of murder and 2 counts of murder while kidnapping in the deaths of Abby Williams and Libby German. Now, the defense case continues, and they called a firearm experts in an attempt to discredit the state's expert firearms examiner who's already testified. Now, Eric Warren is a Tennessee-based forensic consultant and crime scene reconstruction expert. He testified that the prosecution's firearm examiner's method of testing a key piece of physical evidence recovered from the crime scene was unreliable. So last month, a prosecution expert witness by the name of Melissa Oberg, now she works for the Indiana State Police is a firearms examiner. She testified that an unspent round found between the girls' bodies had been cycled through Richard Allen's Sig Sauer P226 handgun, which is .40 caliber, and her testimony was critical to tying Richard Allen to the crime scene. Now, as part of her analysis, Ms. Oberg said she cycled and fired rounds through Allen's handgun so she could compare tool markings left after firing with the markings on the rounds from the crime scene. She explained because firing causes more pressure, the markings would be more distinct. Well, Allen's defense attorneys immediately called into question Oberg's method. Now, with Bradley Rozzi, the attorney for Richard Allen, pointing out that the results of her analysis was based on examining and comparing fired, not unfired rounds. Now, Warren's testimony was meant to call that into question. Quote, "That would be something that I would rely on," Warren said of Oberg's analysis, adding that he was not comfortable with the state's experts' process. Now, Warren, who worked for the Tennessee Bureau of Investigations in their firearms and tool mark identification unit, said that because of pressure differences between fired and unfired rounds, comparisons should be apples to apples, not apples to oranges, which is what you get when you compare them to fired and expelled rounds. Now, during cross-examination, the prosecution questioned Mr. Warren as to why he didn't physically examine the evidence with a microscope and actually prepare a report. And the prosecutor also pointed out that Mr. Warren's conclusions were based only on examining photographs and reading another's expert's reports. Now, Warren also acknowledged that his lab is not accredited, and although he said he believes he meets the standards of accreditation, he has been unable to get that. Now, the jury asked Mr. Warren 15 questions, many of which were highly technical. One juror asked why Mr. Warren didn't conduct his own analysis instead of just reviewing photographs. Warren said his role was to educate the attorneys and to see if the documentation supports the conclusions. Interesting, ladies and gentlemen. Now, oftentimes, the defense is in a very precarious situation. That is the key piece of evidence. They had to find an expert. And the expert, obviously, if he said this was not a match, he would have testified to such. The best he could do was say, we didn't like the process, and therefore you shouldn't trust the conclusion. But he didn't say it wasn't the gun. So remember that. Now, the defense then called Stuart Grayson, a Massachusetts-based psychiatrist and an expert on solitary confinement. Now, he testified that Allen's behavior and mental state while he was at the Westville Correctional Facility are perfectly consistent with the effects of prolonged isolation. Now, Grayson's testimony was meant to discredit, obviously, the dozens of confessions that Allen allegedly made while in custody, where he was being held in solitary confinement for a little over a year. Now, the confessions, which Allen made to prison officials, his therapist, in many calls to his wife and mother, were among the prosecution's strongest evidence against Mr. Allen. But the defense attorneys have alleged that the confessions were coerced because Allen gave them while in the middle of a mental health crisis. Now, Mr. Grayson, who saw videos of Allen, examined his therapist's notes and read transcripts of and listened to audio of calls he made from November of 2022 through June of 2023, and he testified to the jurors that prolonged solitary confinement can cause people to be overly delirious and confused and for their memory of events to disappear. Stripping off clothes and smearing feces, he said, is quite common effect when people live in solitary confinement. He said, quote, "You have this thick soup in your head and everything just floats and nothing makes sense at all," he testified. Now, Allen's bizarre behavior began around the spring of 2023, a few months after he arrived at the Westville Correctional Facility. He began telling his family during several phone calls that he had found God, and that he later began confessing to killing Abby and Libby. As he confessed, Allen also seemed to express confusion and belief that he was losing his mind. He said, quote, "I want to apologize to you," Allen told his wife, end quote. And I did it. I killed Abby and Libby. Now, there was testimony that Kathy Allen, Richard Allen's wife, seemed disturbed and unwilling to believe that her husband was capable of such murders. And she told him as such, "They messed you up. Why would you say that?" "Well, because maybe I did it," Richard Allen said. "Now, there's something wrong," Kathy Allen had told her husband. "They're screwing with you there." Now, Mr. Grayson said people who were in prolonged isolation tend to develop false memories that become their beliefs, and in the worst case, they can become psychotic. Now, the defense attorneys asked Mr. Grayson if he saw indicators of delirium in Allen's calls to his family, and he said, absolutely. The inability to remember and then becoming very frightened by his inability to remember is quite common. He says this is absolutely classic, he testified to. There's no doubt in his mind that's what was taking place. Now, Grayson went on to explain to the jury what solitary confinement is, and confinement in a small cell with minimal opportunity for stimulation and limited social interaction is his definition, and is described in an enormously lonely, helpless environment and very toxic to the mental health. Mr. Grayson also testified that those in solitary confinement are 7 to 9 times more likely to commit suicide than the average person, and he said that the United Nations considers 15 days of solitary confinement to be a form of torture, he explained to the jury. Now, Allen was in solitary confinement at the Westville Correctional Facility for 13 months. Now, one of the jurors asked a question if a completely normal person can go crazy after 6 to 12 months in solitary confinement. And Mr. Grayson said, absolutely, I've seen it happen. Now, Allen's defense team has spent the past few days trying to establish that Allen, contrary to previous testimony, was experiencing a genuine mental health crisis when he allegedly confessed to the killings. And then on Monday, A neuropsychologist told jurors that Allen did not fake psychotic behavior, contradicting testimony from Dr. Monica Walla, Allen's therapist at the Westville facility. Now, Dr. Polly Westcott testified that Allen entered Westville with a long history of depression and anxiety and was later diagnosed with dependent personality disorder, and Allen's mental health problems became more pronounced and escalated to the level of psychosis after months in solitary confinement. Now, ladies and gentlemen, we're going to have to see what the jury believes in this particular situation. Now, not a big fan of solitary confinement. I've seen people in it. I've had clients that have been literally in isolation for a decade at the Supermax facility here in the state of Colorado. And I don't know if it explains all of his behavior, but I think it certainly contributes to some of it. That is for sure. Now, like I said, this is not the strongest case for the prosecution until you throw in the confessions. And so the defense has to be able to try to explain that. Can people go crazy, so to speak, while you are in solitary confinement? I totally believe that. All right. The question is, why do people confess to things they didn't do? No, once again, I've had people that confess to things they didn't do because they were pressured into it by people. But this is the type of situation where if he was truly having a psychotic event, he may have just been saying things, or maybe things that he thought he should believe. We really don't know. The question is, and really it only matters, is what do those 12 jurors who ultimately make the decision? Did he do it? Was it proof beyond a reasonable doubt? Or is there, in fact, reasonable doubt in this particular case? Is it proof beyond a reasonable doubt? I don't know just yet. It's very interesting. I wish this case were televised. We would be able to get a much better feel and judge the credibility of witnesses. So did the defense expert, their toolmark expert, hit it out of the park? No, I don't think so. They were working with what they could probably get. Let's challenge the process, right? Cycle through a round through the same gun to see if you get the same mark on the round. But the prosecution's expert put the gun, they fired the gun to get a greater, deeper impression to make sure it's the same one. That's the process, right? Comparing apples to apples or apples to oranges. And what I mean by the defense was working with what they had to do or what they could use is that my guess is the defense expert couldn't testify under oath that this was in fact not the gun that cycled that round through the chambers. That's what I believe. We'll see what ultimately happens. Next, the Daniel Penny case. You know, that white dude. That's right. The prosecutors and the witness in the trial of Daniel Penny referred to him as the white man or the white dude during testimony while referring to the deceased, Jordan Neely, as Mr. Neely. Now, on day 2 of the trial, where Mr. Penny faces charges relating to the death of Mr. Neely after the latter allegedly threatened New York subway passengers, Yvette Rosario testified about what she saw when Mr. Penny placed Mr. Neely in a chokehold to prevent him from hurting other passengers on the subway. Now, Miss Rosario filmed a short video of Penny restraining Neely in the chokehold and was asked about her experience that day that Mr. Neely died. Rosario apparently didn't know Mr. Penny's name, so she referred to him as the white guy. And the prosecution not only didn't correct her, but began referring to Mr. Penny as the white dude or the white man throughout her testimony. Now, Miss Rosario is from the Dominican Republic, who has lived in the state of New York for 10 years and referred to Mr. Neely as his first name, Mr. Neely. Now, the district attorney did the same throughout the exchange. So when Penny's defense attorneys stepped up for cross-examination, he first pointed out that the white man had a name, and his name was Daniel Penny. Now, Miss Rosario told the jury that she was frightened of Mr. Neely on May 1st when he entered the train, removing his sweater and angrily announcing to everyone that he was homeless, had no money, and didn't care about returning to jail. She said, "I got scared by the tone of his voice. It was very angry tone." Now, in the opening days of the trial, law enforcement said Neely was alive when first responders arrived at the scene, but they didn't give Mr. Neely mouth-to-mouth resuscitation because officers were worried about diseases he may be carrying. He was a apparent drug user, and he was very dirty. New York Police Sergeant Carl Johnson testified during trial. I did not want my officers to put their lips on his mouth. They could get hepatitis or AIDS, and chest compressions would be enough to get him awake. Now, Mr. Daniel Penny, he's 26 years old. He's a former Marine, and he's facing up to 15 years in prison if he's convicted of the manslaughter charge, or 4 years if he's convicted of the lesser charge of criminally negligent homicide. Going to be very interesting. He put him in a chokehold, but he was alive when the police showed up. It's called an intervening cause, ladies and gentlemen. Yes, the chokehold may have put him out, but was that what killed him, right? It has to be the proximate cause, that but for the chokehold, Mr. Neely would not be dead. I think it may be a tough case to make for the prosecution. Next, Lori Vallow gets some new attorneys, and they say, whoa, let's withdraw that motion regarding competency. That's right. Now, Lori Vallow is accused of conspiring in the fatal shooting of her fourth husband, Charles Vallow, and plotting the attempted murder of her ex-niece's husband, Brandon Boudreaux. Now, in the case of Charles Vallow's murder, Lori's late brother, Alex Cox, actually claimed that it was self-defense, and police in Gilbert, Arizona, believed Cox was the shooter in the Boudreaux case. Now, Cox died back in December of 2019, and initially the trial was scheduled for August 1st, but a judge later decided to push the trial to February 24th of 2025. Now, despite Vallow not waiving her right to a speedy trial, the trial has since been put on hold. Anyway, so Vallow was extradited, if you don't recall, back to Arizona in November of 2023 after being sentenced in Idaho to life in prison without the possibility of parole for killing her two youngest children, Joshua J.J. Vallow and Tylee Ryan, and conspiring in the murder of Tammy Daybell. Tammy was the former wife of Chad Daybell, husband number 5. So a little over a week after a judge granted a motion for competency and request for new lawyers for Lori Vallow are asking to withdraw the request to undergo a mental competency evaluations. Now, lawyers for Lori Vallow have filed a motion to withdraw that Rule 11 request. They want more time to review 5 boxes of records as well as a hard drive with 16 terabytes worth of data that they need to decide on what information actually goes to the doctor. Just for frame of reference, I thought this was rather interesting. 1 terabyte is about the equivalent of 250 movies or 6.5 million documents. I'm going to have to remember that little fact when I request a continuance, because now we get cases that have literally 7, 8, 9, 10 terabytes of information. It's amazing the amount of information the police can collect these days. Anyway, in addition, the new attorneys also say they need time to have a meaningful opportunity to speak with Lori Vallow, and that she requests an expedited in-person hearing. Now, Vallow's former defense lawyers filed a motion for the Rule 11 evaluation, the competency evaluation, and they're asking that she be declared incompetent to stand trial in this particular case, just like what took place in Idaho. As you may recall, the attorneys had her comped in Idaho, and it took 10 months for the state of Idaho to restore her back to competency. Like I've said in the past, is she crazy, like mentally not competent to proceed, or is she crazy like a fox? Is she playing everybody? We'll have to wait and see. Next, the lead prosecutor in the Barry Morphew case, officially disbarred. That's right. The 11th Judicial District Attorney, Linda Stanley, was officially removed from office last Friday after a branch of the Colorado Supreme Court ordered that she be disbarred. Now, Ms. Stanley cannot be the district attorney if she does not have a law license. Seems like a reasonable prerequisite to the job. Now, the order that was issued Friday removes her from the office effective immediately and says that she must not engage in the practice of law or aid others in the practice of law. Now, within 14 days of the ruling, Stanley is required to file an affidavit confirming her compliance with the order. Now, the 11th Judicial District Attorney's Office filled the position temporarily with a guy by the name of Jeff Lindsay to finish out Stanley's term, which ends in January. Now, Lindsay is also the only candidate running for the position in the November election and is expected to take the role of the district attorney for Fremont, Chaffee, Custer, and Park counties permanently when his new term begins in 2025. Now, Ms. Stanley lost her law license, and like I said, she's been disbarred following a disciplinary hearing back in June. She appealed the decision, arguing in part that she needed the job to help pay the legal bills and fines that will come with her disbarment. And a panel of the Colorado Supreme Court ruled in an 83-page decision that Ms. Stanley can't practice law in Colorado anymore. She was disbarred for a long list of ethical violations, most of which stem from her handling of the case of Suzanne Morphew's murder. Now, Ms. Stanley brought murder charges against Barry Morphew back in 2021 after his wife went missing from their home in Chaffee County on Mother's Day of 2020. Now, Ms. Stanley was accused of withholding evidence from the defense, launching a secret investigation into the judge on the case, and talking to journalists and podcasters about the case that she was actually prosecuting. Well, last month, she filed a motion to stay her disbarment pending her appeal in the case, which was denied. She then asked the court to stay her disbarment until January of 14, when her term ends. She previously asked the judge to delay that, and once again, that was disbarred. Now, two other attorneys, Mark Hurlbert and Rob Weiner, two prosecutors who worked on the Stanley case, settled a complaint by the Office of Attorney Regulation last month that was filed in response to alleged wrongdoing stemming from their involvement in the Barry Morphew case. I believe theirs was a public censure. Now, Barry Morphew also filed a civil lawsuit against the county prosecutors, the Colorado Bureau of Investigation, employees and FBI employees seeking $15 million over what he claimed was a malicious prosecution brought without sufficient evidence. Anyway, that suit was dismissed by a United States District Court judge in September, claiming governmental immunity. We'll see what Miss Stanley does here in the future, I guess, but it won't be practicing law, at least not in the state of Colorado, that's for sure. Next, a Texas man is going to prison for 40 years for defending his stepdaughter's honor. That's right, a Texas judge is going to send a man to prison for 40 years for murdering another man who allegedly threatened to release naked pictures of his stepdaughter. I got mixed emotions about this, ladies and gentlemen. Probably nice to, defend your stepdaughter's honor, but you probably shouldn't kill anybody. Let's just go there, all right? I think it's a little excessive. Anyway, last Friday, a jury convicted Jesse Clifford Brown on the murder charge back in the 2015 death of John Allen Franco in Liberty City, Texas, which is about 120 miles east of Dallas. Now, the Gregg County Sheriff's Office said the deputies responded about 10 p.m. on May 20th of 2015 to a car crash in the area in their county. But when the deputies responded, they found the man, later identified as Franco, was not suffering from injuries consistent with a car crash. Oh no, it turns out the autopsy determined he died from a gunshot wound to the side of the head. That'll do it. Anyway, Franco, another woman, and his daughter, who was 2 years old at the time, was also in the car, and the woman told deputies that they were driving when a blue truck tried to run them off the road. Franco later stopped at a light when the three men reportedly got out of the truck and walked up to the car. The woman reportedly told the detectives that one of the men had a gun, and Franco hit reverse, but something caused the driver's side window to break. Anyway, the woman could only describe the men as, quote, country looking, end quote. It's the day of the adjectives of describing people, right? White man, white dude, country looking. Anyway, while Franco was still behind the wheel, the car crashed and the woman called 911. Paramedics arrived, goes to the hospital, he's dead. Now, Franco's murder went unsolved for about 2 years until a tipster came forward to identify the three men in question, Brown and two other men who have not been publicly identified. Anyway, the complaint and information reportedly said that one of the men and Brown that night said that the suspect was fuming about Franco allegedly threatened to share nude photos of his stepdaughter. Franco and the stepdaughter were reportedly in a relationship, and per the arrest warrant, the man told the cops the group drove around looking for Franco, even stopping at his house where they thought that he might possibly be. Anyway, the man stated that Brown approached Franco's driver's side window and struck the window with the gun. The man stated that the next thing he heard was a loud boom, and then they fled the scene. Like I said, ladies and gentlemen, it's nice that chivalry is not dead, defending a young woman's honor, but let's not go around killing people, okay? Because you're going to wind up in prison, and then the other two guys aren't going to go to prison, and then you're going to be totally bitter and jealous that they're not going to prison because you are, and even though it's probably your idea. But the point is, good to defend your honor. Don't kill anybody. Call the police. There's crimes against that, ladies and gentlemen. There's crimes against that. What is going on down there in Florida? I don't know if it's something in the water. I don't know. But if there's ever been a reason to do a criminal background check at crimetalksearch.com, this is one of the reasons why you do it. So apparently a Florida man and woman are behind bars after they allegedly attacked a man who just wanted to have sex while being tied up on the beach. Is that too much to ask? I don't think so, right? Now, what is being described as a frantic man flagged down a sheriff deputy about 8:30 p.m. last Wednesday. He was bleeding heavily throughout his body, and the man told the deputy that a man and a woman had jumped him on the beach. He said he and a woman, later identified as Alana Cagle, agreed to come to the beach where she would tie him up and then have sex, according to the arrest affidavit. Cagle picked him up at his home, and they drove to the park where they parked the car and then walked down to the beach. When they got to the beach, he started to feel some odd vibes, right? Like this is a little weird. Obviously, these bad vibes are coming from Miss Cagle, and as she was sitting about 5 feet away from him. Nonetheless, she took out a yellow rope that she had brought with him, and she began to tie him up, just like all of his frantic man's wildest desires and dreams are coming true. Well, apparently at this point, the victim saw another man approaching them. He tried to untie himself, but Cagle jumped on top of his legs, and he was able to fight her off and began to run away. But the other man, later identified as Wayne Streeter, tracked him down and tackled him. Streeter allegedly began choking the man while Cagle punched him in the face. And then Cagle then pulled out a hatchet and began hitting him all over his body with the hatchet. Now, the victim was able to ultimately fight off both of the suspects and ran to get help. He described Cagle's vehicles to the deputies, and they pulled her car over nearby. Now, there allegedly was also a backpack that the victim had left behind. The deputies tried to speak with Cagle, but she requested a lawyer, and then said, post Miranda, Streeter told detectives that he and Cagle are boyfriend and girlfriend. And Streeter said that Cagle picked him up and they drove to the beach. When he then claimed that he saw a man who he didn't know push Cagle down on the beach and he went to save her. See, chivalry is not dead, ladies and gentlemen. Anyway, Streeter said there were no weapons used, but he admitted to choking the victim. Anyway, the deputies went to the beach where they found blood and the yellow rope to tie up the victim, corroborating the victim's story. Needless to say, he suffered multiple lacerations, long cuts to his abdomen. Paramedics took him to the hospital where he was treated. Police arrested Cagle and Streeter on aggravated battery with a deadly weapon. Both have since posted a $5,000 bond. Their next court date is November 26, ladies and gentlemen. What can you do? Unidentified frantic man just trying to have his sexual fantasies come true. Next thing you know, he's attacked. Then you got Streeter defending the honor of Cagle. Let the jury decide. Next on the docket. On November 5th, 1951, President Harry Truman signed the Boggs Act into law. What did that do? It set minimum federal sentences for drug offenders. And the law has never been the same since. And then on November 5th, 1872, women's rights advocate Susan B. Anthony illegally cast her vote in a New York congressional district election. Ultimately, Miss Anthony was fined $100 after a directed verdict. But a little more context, on November 18th of 1872, a deputy marshal arrested Susan B. Anthony for voting in the 1872 presidential election. 2 months later, the indictment charged her with wrongfully and unlawfully voting for a candidate for Congress from the city of Rochester. There in New York, on November 5th of 1872, in the first election district of the 8th Ward of the city of Rochester. Further alleging that she is a person of the female sex, she was charged. Now, she was, like I said, was fined $100 and paid court costs. Now, this is one of several federal court cases involving women arrested illegally voting in the 1872 election there in Rochester. And don't worry, only took 48 years before the 19th Amendment passed in 1920. There's your day in legal history, ladies and gentlemen. And then finally, our dumb criminal of the day. A Houston woman is facing serious charges after she attempted to sell her newborn through social media. Please meet Juniper Bryson. Now, she's only 21, and she's been charged with the sale and purchase of a child and is currently being held in custody on a $30,000 bond. Now, the investigation began back in September when a Houston Police Department received a police report regarding Bryson's alleged attempt to sell her baby on Facebook. Now, just days earlier, on September 21st, Bryson had reportedly reached out to a family connection asking if she knew of any families looking to adopt. Now, during the conversation, Ms. Bryson allegedly disclosed that her baby would test positive for drugs and stated that she was just simply unable to keep the child. Well, Ms. Bryson posted in a Facebook group aimed at connecting birth mothers with prospective adoptive parents, indicating that she was located in Houston but willing to travel if arrangements could be made. And then on September 24th, Bryson gave birth at the hospital with an acquaintance reportedly interested in adopting the child. Well, police allege that at the hospital, Bryson was waiting for the highest bidder to finalize the adoption arrangement. Police were notified after social media users raised concern about the legitimacy of the adoption, and court documents further allege that Ms. Bryson sought compensation in exchange for the baby, a claim backed up by messages to the prospective parents. Ms. Bryson, you are a dumb criminal of the day. Hey, you had the baby. Wish you had been able to do it without doing drugs, for sure. And there's lots of people that would love to adopt children these days, but you can't go around selling your child to the highest bidder. Ms. Bryson, don't do that. It's against the law. All right, that's all we have for today. Hope you enjoyed the show. Hope you went out and voted. We'll see you tomorrow. And remember, the Constitution matters.